The room had gone quiet in the particular way federal hearing rooms go quiet. Not silence exactly, but the sound of a dozen people trying not to move. $40 million and my father's name on a patent were sitting on the table in front of us, and for the moment, neither one belonged to anyone.
I watched the witness study the exhibit longer than anyone expected him to. Chief Warrant Officer Marcus Ibarra held the printout at arm's length, the way people check their own eyes instead of the page in front of them. His uniform was pressed, the way older career soldiers still press their uniforms, even for a desk assignment. And for a moment, he just looked at the paper like it belonged to someone else's file. Then he looked up, past the hearing officer, past my husband's attorney, and stopped on a number typed in the corner of a second document.
He asked a question nobody in that room had thought to ask yet. One plain line, delivered so quietly that it took Bradley Ashcroft a full second to understand he was the one who needed to answer it.
Nobody had prompted him. He was asking it himself.
Bradley Ashcroft, seated beside the man I was still legally married to, glanced down at his notes, like the answer might be hiding somewhere in them. It wasn't. I watched his pen stop moving. Beside him, Colin sat very straight, the way he used to sit in church as a kid, according to something he'd told me years ago in a different life. He didn't look at the exhibit. He looked at his own hands. I sat very still, my folder closed in my lap for the first time all morning. 8 months earlier, when I first opened my father's old workbench and found the box that started all of this, I never imagined it would end in a room like this one. Fluorescent lights, a government seal on the wall, a stranger in uniform staring at a 9-digit serial number like it had just said his name out loud.
In a way, it had.
I just didn't know that yet. 8 months earlier, I was standing in my father's workshop holding a coffee mug that had gone cold 2 hours before, and I still hadn't found the nerve to wash it out. I didn't know yet that the filing cabinet a few feet behind me held the reason a federal hearing officer would someday ask a stranger in uniform to explain a 9-digit number out loud. I only knew that the coffee was cold, and that I hadn't figured out how to be in that room without him in it too. My father, Walter Ellery, had died in his sleep on a Tuesday in October, 66 years old. A heart that had carried him through 2 combat deployments as an Army field medic, and then 30 more years as a civilian engineer, and one morning it simply decided it was finished. My aunt found him. She called me before she called the funeral home, because she knew, correctly, that I would want to be the one to walk into that house first. He didn't leave behind much in the way of money. He left behind a small company with his name stenciled on frosted glass, Ellery Medical Innovations, 4 employees, a leased warehouse space that smelled permanently of solder, and a filing cabinet full of patent drawings he'd worked on since before I could walk. The company wasn't going to make anyone rich. My father used to say that like it was a point of pride, the way some men say it about their fishing boats. What it had made, slowly, over almost 2 decades, was the AutoStanch, a self-regulating pressure app that could sense blood loss and adjust itself automatically, built for the exact 10 minutes after a soldier goes down and before help can reach him. He designed it, in large part, because of me. Not because I asked him to, because I came home from a deployment in late 2019 with a piece of broken equipment at the bottom of my duffel bag and no idea what I was carrying. I'll get to that. What matters first is that he spent the last 3 years of his life finishing that device, and 2 weeks before he died, a mid-sized medical technology company called Vantage Biomedical made an offer to license it. Real money, the kind that could fund a foundation or a retirement, or, as it turned out, a war. I was standing in his workshop that morning because someone had to sort through what he'd left, and there was no one else left to do it. My mother had passed when I was in college. I was an only child. My husband, Colin, was somewhere in another part of my own life entirely, filling out paperwork with a lawyer neither of us had wanted to need. I picked up the mug. It had his handwriting on a piece of tape wrapped around the handle, a habit from a lab where 4 people shared one coffee pot and nobody trusted anybody else's mug hygiene. I didn't wash it that day. I set it back down exactly where it had been sitting and went home instead. I should explain the marriage before I explain the lawsuit, because the two are not separate stories. They are the same story, told from 2 directions. Colin Doyle and I had been married 6 years.
He ran a landscaping and hardscaping company, Doyle Outdoor Design, that had done well enough in its first few years to convince him to open a second location 2 counties over. The second location did not do well. Permitting delays ate a season. A key crew foreman left for a competitor. By the time my father died, Colin was carrying more debt against the business than either of us had ever said out loud to each other, and I had already filed for divorce 4 months earlier. That part had nothing to do with my father's patent. I want to be clear about that, because it would be easy to tell this story as though the money caused everything, and it didn't. I filed because 6 years of marriage had quietly become 6 years of me managing both of our lives, while Colin managed his own disappointment, and I was tired of being the only adult in the room. It was ordinary. It was sad in an ordinary way, the kind of ending that doesn't have a villain in it, or didn't, until it did. For the first several weeks after my father died, Colin was kind to me. Genuinely kind, I think. He came to the funeral, even though our attorneys had already exchanged paperwork by then. He carried boxes out of the house without being asked. He sat with me one night while I cried over that same coffee mug and didn't say anything, which was exactly right. And for an hour or two, I let myself forget we were also, technically, divorcing. Then the Vantage biomedical deal started moving toward a signature, and something in him changed. I noticed it first in small ways. He started asking specific questions about the licensing terms, not out of curiosity, but with a kind of precision he'd never shown interest in before. He mentioned twice in the space of a week all those nights out in your dad's shop, in a tone that made the phrase sound less like a memory and more like an opening argument. I told myself I was imagining it. I had by then spent years telling myself that about smaller things. There was a dinner, maybe 8 months before my father died, that I keep coming back to now. My father's college roommate was in town, and the 4 of us, Colin, my father, the roommate, and I, ended up at a restaurant talking about the auto stanch, which was close to finished by then, and had everyone at the table a little proud and a little loose with wine. Colin told the story of a night the prototype's power supply had failed at 2 a.m, and how we had stayed up rewiring it until it worked. It was a real memory. He had been there. He had, in fact, held a soldering iron for part of it. But the way he told it, leaning forward, using words like, "We troubleshotted the circuit," instead of, "I held the flashlight while your dad troubleshotted the circuit," turned an evening of company into an evening of collaboration. My father laughed along, the way you laugh along with a son-in-law's story at a dinner table, and didn't correct it. Neither did I. I remember thinking on the drive home that I should say something to Colin privately, not to embarrass him, just to keep the record straight before it calcified into something else. I didn't. It felt small. It felt like the kind of correction that costs you more in the room than it's worth, and I had gotten very good over 6 years at deciding things weren't worth it. I think about that dinner often now, not because it caused what happened later. I don't believe any single evening causes something like this, but because it was one of maybe 100 identical evenings, and I let every one of them go by unspoken. And somewhere in that accumulation, Colin found enough material to build a story he eventually came to believe himself. It happened first at our divorce mediation, of all places, a conference room with beige walls and a box of tissues nobody had touched. My attorney on one side of a long table, Colin's on the other, a mediator sitting at the head trying to keep both sides moving towards something efficient. We were working through the property division. It was supposed to be simple. My father's estate had passed to me directly, outside the marital assets, and everyone in the room knew that going in. Then Colin's attorney at the time, not Bradley yet, an earlier one, cleared his throat and said something that made my own attorney go very still. My client contends that he made substantial technical contributions to the auto stanch system, beginning in 2016. We believe that entitles him to a share of the pending licensing revenue as marital property, regardless of how the estate was structured. I looked at Colin. He wasn't looking at me. He was looking at the table. "Those nights I spent out in your dad's workshop weren't nothing, Dana," he said, quiet enough that the mediator had to lean in slightly to catch it. "You know that. You were gone more than you were home most of those years, and somebody still had to be the one standing next to him." I did know it. I remembered them clearly. Colin helping my father move a heavy testing rig off a truck one Saturday, holding a flashlight steady while Walter rewired something under the bench. The three of us eating pizza out of the box at midnight because a prototype had blown a fuse and nobody wanted to stop until it worked again. I never once thought of any of that as engineering. I don't believe my father did either. He liked Colin's company. That was different from crediting him with the invention. But there's a difference between being present in a room and being credited with what happens inside it. And somewhere in the last several months, Colin had stopped seeing that difference, or had decided he no longer needed to.
My attorney requested a short recess. In the hallway, she asked me the only question that mattered. Is any part of what he's saying technically true? He was there sometimes, I said. He helped with things, not the censor, not the parts that actually matter.
Then we're not settling this today, she said, and went back inside to request a continuance specifically on the patent-related portion of the property division. The family court judge granted it without much comment, a routine administrative stay, pending resolution of what she called, almost offhandedly, the underlying ownership question.
Colin's attorney didn't object to the stay. I understood why much later. A delay was exactly what they wanted.
I want to be honest about something before I go further. My first instinct, walking out of that mediation, wasn't anger. It was guilt. For 6 years, I had let Colin describe himself, at dinner parties and family gatherings, as someone who helped out with my father's invention. I never corrected it in front of other people, because correcting it always felt like taking something small away from a man who already believed he had very little to hold on to. I told myself it didn't matter. Words at a dinner party don't matter. I was wrong about that. Words, left uncorrected long enough, stop sounding like small talk and start sounding like history. I had spent 6 years being generous with a story that wasn't mine to give away, and now someone was trying to collect on it. I didn't agree to Colin's claim that day. I also didn't fight it there, not fully. I asked for time to understand what I was actually dealing with, and I got it, in the form of that stay.
2 weeks later, I found out exactly what I was dealing with. The call came from Vantage Biomedical's licensing counsel. Polite, professional, devastating in the specific, bloodless way that only a lawyer's voicemail can be. They were placing the agreement on hold, not canceling it, holding it, until, in the words of the letter that followed, the inventorship of the underlying patent application is clarified between the named parties. I didn't understand what that meant until I read the attachment. Colin had filed a formal declaration with the United States Patent and Trademark Office, claiming he was a co-inventor of the AutoStanch system's core sensor architecture, with contributions beginning in 2016. Under federal patent law, correcting the inventors listed on a patent is a serious act. It requires a signed statement made under penalty of perjury, specifically describing what the person contributed and when. Colin had signed one. My father's name was still listed first, but now Colin's name sat beside it, and every dollar of the $40 million Vantage deal was frozen until a federal hearing officer could determine who was telling the truth. I sat at my kitchen table and read that letter 3 times before I let myself feel anything about it at all. I want to tell you what I decided next, because it's the moment everything else in this account hangs on. I could have called Colin and asked him, quietly, to walk it back. Some part of me almost did. 6 years of marriage doesn't disappear the day you file the paperwork, and some part of me still wanted this to be a misunderstanding I could talk my way out of, the way I'd talked myself out of every earlier disagreement between us. Instead, I opened a plain composition notebook I'd bought years ago and never used, and I wrote a date at the top of the first page. It's a habit I learned long before I ever met Colin. In trauma care, you chart everything, every intervention, every minute, every change in a patient's condition, because memory lies under pressure, and paper doesn't. Adrenaline makes people certain of things that never happened, and it makes them forget things that did. I hadn't used that habit for anything but a medical chart in almost 4 years. I decided that afternoon to use it for this instead. I want to say clearly that I wasn't trying to destroy Colin. It would have been easy to want that, and for a few minutes at that table, sitting alone with a letter that had just cost my father's company $40 million, I did want it. What I actually settled on, once the anger burned down, was simpler and harder to hold on to. I wanted the truth documented,
before anyone else got to decide what it was. I wrote a single line at the top of the page, confirmed facts only, and started with the one date I already knew for certain, my father's earliest sketch of the sensor mechanism, filed in his own logbook, dated 2019. I didn't know yet how far that single line would take me. I called an intellectual property attorney the next morning. The first one I reached quoted a retainer larger than anything I had liquid. The second was booked through the following spring. On my third call, a veterans legal assistance network I found through an old Army contact connected me with a small firm that took on complex cases involving service-connected inventors, and an attorney named Denise Okafor agreed to meet with me 2 days later. Her office was small. One paralegal, a waiting room with mismatched chairs, a framed photo on her desk of a man in dress uniform who I later learned was her late husband. She was direct in a way I appreciated immediately, and she didn't waste time pretending this would be easy. "I want to be honest with you before we start," she said, sliding a legal pad across the desk. "Correcting inventorship at the federal level is expensive, slow, and it almost never comes down to who has the better story. It comes down to who has better paper. If you don't have contemporaneous records, things written down at the time, not reconstructed later, this gets much harder and much more expensive." "I have some of my father's notebooks," I said. "Not Colin's, his." "Good. What about anything from your side of things? Anything that puts a specific, verifiable date on when the sensor technology in this device actually became available in the first place?" I didn't have an answer for her that day, and I told her so. She didn't seem surprised. "Most people don't walking in here," she said. "That's fine. We build it. But I want you to understand something now, before we go further, because I've watched this break people who weren't ready for it. Colin's attorney is going to make this personal. He's going to paint you as a bitter, grieving daughter, trying to erase a man's real contribution out of spite. You need to decide right now whether you can sit in a room and let that happen without losing your composure. Because if you can't, we lose before we start." "I can sit in a room," I said. "I've sat in worse ones." Something in her expression shifted. Not quite a smile, but close. 12 years in, I'm guessing, from the way you carry that folder. "Combat trauma nurse. 2 deployments. Then you already know how to build a case file under pressure. Most of my clients, I have to teach that from zero." She tapped the notebook I'd brought with me, the one with confirmed facts only written across the top in my own handwriting. "You came in already running." That was the first moment since Colin's declaration landed in my inbox that I felt something other than dread. It didn't last long, but it was there. The following Saturday, I drove out to my father's workshop alone. I want to describe it honestly, because there was nothing cinematic about it, whatever this might sound like now. It smelled like solder and old coffee grounds. The overhead fluorescent buzzed on one side, the way it always had, the way he'd meant to fix for at least 5 years and never did. A half-finished prototype sat under a dust cloth on the main workbench, exactly where he'd left it the week he went into the hospital, for what everyone assumed was a routine checkup. I wasn't looking for a smoking gun. I don't believe in those, not really. Not the kind that solve everything in one dramatic sweep. I was looking for a timeline, the same way I'd build one for a confusing patient history. Start with what's verifiable and build outward from there, one dated entry at a time. I found my father's engineering notebooks in a filing cabinet, organized by year in his cramped, precise handwriting, the same handwriting that used to sign my school permission slips. The earliest sketches of the autostanch's pressure mechanism went back to 2014, mostly rough concept drawings, dead ends, crossed out math in the margins. The sensor system, the part that actually monitored blood loss in real time and adjusted the wrap automatically, didn't appear in any of his drawings until a page dated November 2019, with a note in the margin that made my hands go still the first time I read it. "Component courtesy of D. EMAL trial unit. Damaged. Disposal off. See what it can do." D. My father's shorthand for me. Then I found the box. It was an old plastic footlocker I'd carried through 2 duty stations and never fully unpacked, shoved into the back corner of the workshop closet where I'd left it years ago and mostly forgotten. Inside were things I hadn't looked at in a long time. A set of dog tags, a folded flag from a retirement ceremony that wasn't mine, unit patches, and a thin stack of government paperwork I'd tossed in there and never sorted.
Near the bottom was a single sheet, government gray, titled Equipment Issue and Disposition Record. My own signature sat at the bottom, beside a supply sergeant's. It authorized the personal disposition of a damaged trial-issue casualty monitoring sensor module, part of a limited Army evaluation program, following a deployment to a forward surgical station, dated the spring of 2019.
I remembered the module then, all at once, the way memory sometimes returns whole instead of in pieces. It had been damaged beyond field repair, marked for disposal, and I'd asked, almost as an afterthought on my way out of theater, whether I could keep it. I thought my father would find it interesting to take apart. He liked things like that. I had no idea, at the time, that I was carrying home the missing piece of a device that would one day be worth $40 million, or that I'd spend a year of my life proving exactly when that piece had come into existence. I sat on the workshop floor with that paper in my hands for a long time before I trusted myself to drive home.
I didn't call Colin. I called Denise.
She was quiet on the phone while I read her the date on the disposition record, and when she spoke again, her voice had changed, steadier, sharper, the sound of someone recalculating a case in real time.
Dana, if that module genuinely wasn't accessible before 2019, if it didn't exist in any usable, obtainable form before then, and Colin's declaration claims he contributed to that exact sensor architecture beginning in 2016, that isn't a disagreement about memory anymore.
What is it then? It's a factual impossibility, and factual impossibilities are exactly the kind of thing a hearing officer can rule on cleanly without anyone needing to decide whose feelings are more valid. But I need to be careful here, and so do you. We can't just say it. We need someone with actual, independent authority over that equipment program to confirm it. Not your father's notes, not your memory. A source with nothing to gain either way.
I don't know how to find someone like that.
You don't have to. The federal review process usually does it for us, if the equipment has a military origin. I've seen it happen with dual-use technology before. It just takes time, and it takes the record staying clean until then.
I didn't know yet that the Army kept issuance records precise enough to trace a single trial component back to a specific unit, on a specific date, through a specific issuing officer. I was about to find out, though, not for several more weeks.
Before that happened, I had one more conversation I want to include here, because I don't think this account is honest without it.
Colin called me the following week and asked if we could talk without lawyers. Against my better judgment, and against Denise's fairly direct advice, I agreed.
We sat in his truck outside my apartment, engine off, both of us staring straight ahead through the windshield instead of at each other, the way you do when a conversation feels safer without eye contact attached to it.
You don't understand what this year has looked like from where I'm sitting, he said. The second location is bleeding money every month I keep it open. I'm about to lose the house I put up as collateral for the expansion loan. And I keep thinking about all those nights in your dad's garage. And somewhere along the way, I started believing I earned something real out of them.
You were there, Colin. Being there isn't the same as building it.
It felt the same, some nights.
Feeling the same isn't the same either.
He didn't answer that right away. For a moment, something in me, the part that had been married to him for 6 years, that had genuinely loved him for most of them, wanted to fix this quietly, the way I'd fixed 100 smaller things before, without either of us having to say the hard part out loud. Then I thought about the letter from Vantage, sitting on my kitchen table, and the 4 employees at my father's company, who hadn't done anything wrong, and were quietly updating their resumes, and I didn't soften.
I'm not going to pretend this didn't happen, I told him. Whatever comes next, it isn't going to be because I decided to look away from it. I did enough of that for 6 years.
He nodded slowly, the way people nod when they already know something is true, and are only now letting themselves hear it out loud. And neither of us spoke again until the hearing.
I called an old friend that night instead of going home to an empty apartment, Priya Chandra, a former unit mate who now worked as a physician assistant 2 states over. We hadn't spoken in almost a year, but some friendships just pick back up mid-sentence.
You sound like you did the week before a deployment brief, she said. That specific kind of calm that isn't actually calm.
I found out my husband might legally own part of my dead father's invention today. Soon to be ex-husband.
Jesus, Dana. I keep waiting to feel something bigger about it. Mostly I just feel tired.
That's what carrying something correctly usually feels like, if you ask me. It's the people who feel nothing who worry me. You remember that mass casualty night at the FOB when you didn't sleep for 2 days straight and you were still charting vitals in that same tiny, perfect handwriting the whole time? You said if you stopped writing things down accurately, people died, and that was a better reason to keep going than feeling okay. Sounds like the same job to me, just a different kind of casualty.
It didn't fix the freeze on the Vantage deal or make Colin's declaration disappear, but I hung up that night with something I hadn't had in weeks. The sense that I was fighting this the way I'd been trained to, and that training had never once failed a patient who needed the truth more than comfort.
Denise's office took a deposition from Colin's older sister, Renee, a few weeks after that. Renee worked as a paralegal at a small general practice firm across town, and it was Renee, we learned, who had drafted the document Colin's new attorney, Bradley Ashcroft, brought on after the first attorney's continuance strategy stalled, called a collaboration memorandum, a 2-page summary of Colin's supposed technical role, carefully worded and carefully dated, meant to read as corroboration for his federal declaration.
Renee was guarded through most of the deposition, seated across a conference table with her hands folded a little too precisely in front of her. She used legal phrases the way people wear borrowed clothes, carefully, a little stiffly, hoping no one notices the fit is wrong.
I helped my brother organize his recollection of events, she said, when Denise asked what the memorandum represented. I didn't fabricate anything.
Did you independently verify any of the technical claims described in it? Denise asked.
A pause, longer than the last one.
That wasn't really my role. Whose role was it?
Renee didn't answer that one directly. Instead, she looked down at her folded hands and said something that wasn't in response to the question at all. I told him the date felt too specific. Colin doesn't remember exact years for anything. Not our mother's diagnosis, not his own wedding anniversary half the time. But when it came to this, suddenly it was 2016, precisely.
Did you raise that with him?
I did. He said, "Renee, just help me write it down the way I remember it." And I did, because he's my little brother, and he was scared. And I told myself that being scared doesn't make someone a liar.
It wasn't a confession. Denise was careful to note, afterward, that it didn't rise anywhere near one. But watching Renee across that table, I remember thinking she looked less like someone protecting a lie and more like someone standing very close to the edge of one, trying to decide, in real time, which side of it she actually wanted to be on.
The family court's stay on the property division held through that period, and Colin's side, for a while, had every reason to feel confident.
Radley filed a motion arguing that the federal review of Colin's declaration should be handled as a routine administrative matter without an evidentiary hearing, essentially asking the process to move forward on paper alone with minimal outside scrutiny. For nearly 3 weeks, it looked like it might work. The family court extended its 90-day stay a second time, at Bradley's request, pending federal clarification. Vantage's counsel, growing impatient, sent a second letter making clear the licensing window wouldn't stay open indefinitely. Colin texted me once during that stretch. "Hope the lawyers are earning their money. It's going to take more than a workshop notebook to unwind this, Dana."
I didn't answer. I saved the message instead, the way Denise had told me to save everything, useful or not.
For those 3 weeks, I believed more than once that he might actually be right.
I drove out to Ellery Medical Innovations that same week, mostly because I didn't know what else to do with the fear, and found all 4 employees in the break room instead of at their benches, a bad sign in a company that small.
Marisol Vega, my father's lead technician for the better part of a decade, was the one who said it out loud. Vantage's counsel called our office manager this morning, asked whether the company had contingency plans if the deal fell through entirely. "It's not falling through," I said, with more confidence than I actually had.
I've got a kid starting college in the fall, Dana. She wasn't accusing me of anything. She just needed to say it to someone who understood what the number meant. I'm not trying to put pressure on you. I just need to know whether I should start looking.
I didn't have an answer that would have been honest and reassuring at the same time, so I gave her the honest one. I don't know yet. I know what I found in his workshop. I don't know yet if it's enough.
She nodded slowly, the way people nod when they've decided to trust someone with their rent anyway. Your dad talked about you a lot in here, you know? Not the war stuff, the stubborn stuff. He said you were the only person he'd ever met who chased down a number until it either made sense or admitted it was wrong.
He used to say that like it was a compliment. It was, she said. It still is. I left that afternoon with something I hadn't had walking in. Not confidence, exactly, but a sharper, more specific reason to keep going than my own name on a patent. 4 people's mortgages and 1 kid's tuition had just become part of the ledger I was keeping in that notebook, whether I'd meant to add them or not. What changed it was a routine flag, not a dramatic one. Because the auto-stanchious sensor architecture had originated from a restricted military issue component, the Patent Office's review process required additional verification before any correction of inventorship could move forward. A standard step, Denise told me, in any case touching equipment with a defense-related origin. That step brought in a materiel officer with custody of the original issuance records for the trial program in question to confirm independently when and to whom that equipment had actually been released. That officer was Chief Warrant Officer Marcus Ibarra. I didn't know his name until the week before the hearing was scheduled. I certainly didn't know that a few years earlier, in a different unit, in a different theater, he had personally been responsible for signing off on equipment issued to a small number of forward surgical teams during a limited trial evaluation. The exact program that had put a broken sensor module into my hands in the spring of 2019.
I want to be precise about this because it matters to the shape of everything that follows. I didn't seek him out. Denise didn't request him by name. He was assigned to the review because his current office happened to hold custody of the original records for that trial program, and someone in that office, all these years later, happened to still be him.
Denise called me 3 days before the hearing to walk through what to expect. The Patent Office is sending a materiel officer to speak to the equipment history, she said. That's fairly standard for anything with a defense origin. Nothing unusual about it procedurally. I don't have a name yet. I don't think it matters much who it is, as long as the records hold up. What if they don't? Then we're back to arguing credibility instead of facts, and credibility fights are exactly what Bradley wants, so we make sure it doesn't come to that. She had me walk through my own testimony twice that afternoon, out loud. Timeline first, feelings last. The same order I'd have used presenting a patient's history on rounds. Don't editorialize on the stand, she said. Let the dates do the editorializing for you. Judges and hearing officers have heard 1,000 people insist they're honest. They've heard far fewer timelines that simply can't be argued with. I didn't sleep well the 2 nights before the hearing. I kept running the numbers in my head anyway, the way I used to run a differential diagnosis at 3 in the morning on a slow shift. Not because it helped, but because it was the only thing that made the waiting feel like it was doing something. I only learned who the material officer actually was and what he'd once had to do with my own deployment the morning of the hearing itself, when Bradley objected to his presence on the record and was overruled without much discussion. The hearing took place on a gray Thursday morning in a federal building downtown. Too much fluorescent light, not enough air, the specific hush of a room built for procedure rather than comfort. Colin sat beside Bradley Ashcroft, his shoulders set in a way I recognized from 6 years of watching him brace for bad news. Renee sat 2 rows back, alone, her hands folded the same careful way they'd been folded across that conference table weeks earlier. I sat beside Denise, with a folder in front of me considerably thicker than the one I'd carried into the mediation session 8 months before. Bradley opened with the argument he'd clearly built the entire case around. Mr. Doyle isn't claiming to have single-handedly built this device, he said. He's claiming a specific, discrete technical contribution to the sensor system beginning in 2016, a claim supported by his own sworn declaration and by a corroborating memorandum from a witness with direct knowledge. That claim deserves to be tested on its merits, not dismissed on the word of a grieving family member with an obvious financial interest in the outcome. I felt the word grieving land exactly where he wanted it to. Denise's hand found my forearm under the table, briefly, a small pressure that meant don't react. The hearing officer turned to her. Miss Okafor? Denise stood and, in under a minute, laid out the timeline in plain, unadorned language. Walter Ellery's engineering notebooks, showing no sensor architecture whatsoever before late 2019,
the equipment issue and disposition record documenting the trial module's release to a specific individual that same spring, and a formal request that Chief Warrant Officer Ibarra confirm under oath the actual availability and issuance history of that component.
The hearing officer looked toward the witness table. Chief Ibarra, are you prepared to speak to the issuance record for this equipment class?
I am.
I've replayed what happened next more times than I can count, and it never takes longer than it actually took. Perhaps 90 seconds from the first real question to the moment the whole room understood what it meant. Denise handed him the exhibit, a photocopy of the original disposition record, my signature at the bottom, the paper slightly yellowed from 3 years in a footlocker. Chief Ibarra, can you identify the equipment referenced in this document? He studied it for a moment. Yes, this is a trial-issue casualty monitoring sensor module. It was fielded to a small number of forward surgical teams for a single evaluation cycle under a limited research program.
When did issuance of this equipment class begin?
Spring of 2019.
Bradley leaned toward Colin and murmured something. Colin shook his head slightly, almost imperceptibly, the gesture of a man telling someone, "It's fine, it's just a formality."
Prior to that date, Denise continued, was this technology available in any form outside the unit selected for the trial, commercially, academically, or through any other channel? No, it didn't exist in any accessible form before that. Fewer than 200 units were ever produced, and the program was discontinued after that single evaluation cycle.
Chief Ibarra, is it possible a civilian with no connection to that trial program could have obtained detailed knowledge of this sensor's internal architecture prior to March of 2019? Not through any channel I'm aware of, no. The specifications weren't published. The units weren't sold, leased, or distributed outside the evaluating teams. As far as the government's own records show, this technology simply did not exist anywhere a civilian engineer could have reached it before that spring. Bradley stood then, more out of instinct than strategy, and asked to see the exhibit himself. Denise passed him a copy. He held it for a moment, scanning it the way a man scans a document, hoping it will read differently the second time. That was when Chief Ibarra looked up from the disposition record, found the serial number printed in the corner of a second exhibit, a fabricated bench testing log Colin's own retained expert had submitted, describing early prototype sensor evaluation, and asked the question that had opened the account I've been telling you. Where did you say this component was issued?
Bradley didn't have an answer, because Bradley genuinely didn't know one. I don't believe Colin did either, not in any way he could have named out loud in that moment. I think in the most human and least excusable way a person can be wrong, he had spent so many quiet years rewriting a handful of ordinary evenings in a workshop into something larger that he had honestly stopped being able to tell which parts of the story were true.
Mr. Doyle, the hearing officer said, your declaration states your technical contribution to this sensor system began in 2016.
Colin didn't look at her. He looked at the table in front of him.
I believed that when I signed it, he said quietly.
Do you believe it now?
The silence lasted long enough that I could hear the building's air handling system cycle somewhere above us. No, he said finally. I don't think I do. Behind me, I heard Renee exhale. Not relief, exactly. More like the sound of someone finally setting down something they'd been carrying for weeks without permission to put it away. Bradley closed the folder in front of him slowly, the way you close a folder when you already know you won't be opening it again in this room. Colin didn't look at me. He kept his eyes on the hearing officer, or maybe just on the table in front of her. And for a moment, he looked less like the man who'd built a landscaping company from nothing, and more like someone very young, caught in a version of the truth he hadn't meant to build as carefully as he had. The hearing officer didn't need much more than that. She entered a formal finding that Colin's declaration could not be substantiated against the independently verified equipment record, and referred the sworn statement itself for further review, a process that, Denise explained to me afterward, could range from a corrected public filing to a federal referral, depending on what additional evidence, if any, surfaced regarding deliberate falsification. Bradley requested a brief recess before formally withdrawing as counsel of record. He did it quietly, without theater, the way a man steps back from a wall he's just watched turn out to be built on nothing at all.
I didn't feel triumphant sitting there. I want to be honest about that, because it would be simpler to tell you I did. What I felt was the particular exhaustion that comes after holding something steady with both hands for a long time, and finally being allowed to set it down. Within the week, the patent office's review closed formally. Colin's name was struck from the correction request, and Vantage Biomedical's licensing counsel called to reschedule the signing for the following month. The family court lifted its stay the same week, and freed of the one asset that had turned an ordinary divorce into something else entirely, the rest of the proceeding finalized within 30 days. The numbers, in the end, were almost bureaucratically tidy. The Vantage agreement closed at just over $40 million across its term, exactly as originally structured. Colin was ordered to reimburse a portion of the legal costs directly attributable to the federal review, a little over $180,000, a sum that Denise told me, quietly, would likely take him years to pay off, given the state of his business.
Renee reached out to me before that final order was entered, without her attorney present, and without asking for anything in return. She handed Denise a folder of her own, internal messages between herself and Colin from the weeks before the declaration was filed, showing she'd raised concerns about the specific 2016 date more than once, and had been told more than once not to worry about it, that it was close enough, that nobody would check that hard.
I didn't pursue anything further against her. I want to be honest that this wasn't purely generosity on my part. Denise advised that Renee's voluntary disclosure, made before any subpoena compelled it, meaningfully limited whatever exposure she might have had. But it was also a choice I made on purpose. I had already gotten what I needed from this fight. I didn't need to spend what was left of it on someone who, in the end, chose to hand over the truth before she was forced to.
Colin and I spoke once more, a few weeks later, in the parking lot of the storage facility where the last of our shared belongings sat divided between two units instead of one house. "I keep trying to figure out when I actually started believing it," he said, "the 2016 part. I don't think I sat down one day and decided to lie. It just got more solid every time I said it out loud, until it stopped feeling like something I was choosing to believe and started feeling like something that had just always been true."
"I don't think you decided to lie either," I told him. "I think you decided you deserved to be right about something, and then you found a story that let you be, and you kept telling it until you couldn't hear the seams anymore." He didn't argue with that. He just nodded, the way people do when something lands closer to true than they wanted it to.
"I'm sorry," he said. "I don't know if that means anything at this point."
"It means something," I said. "It doesn't fix anything. Those aren't the same thing, and I think that's actually the whole lesson, if you're looking for one." We didn't hug goodbye. It wasn't that kind of ending, but it was at least an honest one, and after the year I'd had, that felt like more than enough. I finalized the Vantage Biomedical agreement 6 weeks later, sitting at the same kitchen table where I'd first read the letter that froze everything. My father's company kept its name on the door. All 4 employees kept their jobs. And a portion of the licensing revenue went, exactly as I'd started planning the night I found that equipment record in his old footlocker, towards something that carried his name and had nothing to do with any of this fight. I called it the Ellery Veterans Innovation Fund. It provides small grants to veterans working on their own medical device ideas, and a modest amount of direct financial and legal support for veteran families, navigating exactly the kind of tangled, expensive proceeding I had just come through, largely alone, for most of it. The first grant went to a former combat medic building a lighter cold weather wound dressing out of her own garage. I sat in on her interview, listening to her describe her prototype with the same stubborn, specific focus I remembered watching my father hunch over his workbench with for 20 years. And I thought, not for the first time, that this was probably closer to what he'd actually wanted out of any of it than the money ever was. I still have that old equipment issue and disposition record. It's framed now, hanging in what used to be my father's workshop, beside one of his original hand-drawn sketches of the autostanch's pressure mechanism. 2 pieces of paper, 5 years apart, that turned out to be the same story. I spent most of that year being asked in one form or another to prove I was telling the truth. Judges asked, attorneys asked. For a while, even I asked myself, in the quiet moments when doubt tries to convince you that certainty is the same thing as arrogance. What I learned, in the end, wasn't really about patents or marriages or courtrooms. It was that the truth doesn't need you to defend it loudly. It needs you to write it down, keep it in order, and be patient enough to let it hold its own weight when someone finally asks the right question in the right room. Chief Ibarra didn't come to that hearing to save me. He came because a records office happened to be his, and a number on a page happened to match one from a few years earlier. I didn't build that coincidence. I only made sure that when it finally arrived, there was enough evidence sitting next to it to matter.
If any part of this reminds you of your own family, your own paperwork, your own quiet year of being underestimated by someone who is supposed to know you better than that, I'd like to hear about it. And if you know someone still carrying a fight like this one alone, without the resources or the confidence to start, send them this. There are legal aid networks built specifically for veterans and their families, and reaching out for that kind of help isn't a failure. It's the same discipline I use to chart a patient's vitals under fire, aimed at a different kind of emergency.
I'm not going to tell you revenge feels good. It didn't. Not really. Not even at the end. What felt good, what still does most days, is knowing my father's name is still on that patent exactly the way he wrote it, and that somewhere, right now, a device he built out of a broken sensor and a folded piece of government paper is keeping someone alive who will never know either of our names.
That's the part of this year I'd choose again, every time.
I think sometimes about the version where I never opened that footlocker, where I let the mediation stand and simply paid Colin to make the fight go away, the way his sister once quietly hoped I would. It would have cost less and taken less time, but I don't think I could have kept working the way my father taught me to. Chart it, verify it, don't let a comfortable version replace an accurate one, and still let that lie stand uncorrected in a federal record with his name on it. Some things you let go because they don't matter. This was never one of them.
I don't know what happens to Colin next. I know he's still paying down what the hearing ordered him to pay, a little at a time, the way most consequences actually arrive. Not all at once, but in installments, long after the room has emptied out and everyone has gone back to their separate lives. I hope, honestly, that he finds something of his own to build eventually, something he doesn't need to borrow the shape of from somebody else's workbench. I'm just no longer the person responsible for handing it to him.